Hi, I'm Bill Browning from the law firm of Browning, Meyer & Ball in Columbus, Ohio, former NAILA president, and my pleasure to give you a little intro today on Medicaid planning and spousal circumstances. One of the most common factual scenarios that we see in our office is a circumstance where a wife or husband comes in and says, my husband has been placed in a nursing home this past week and I need your help. Or my husband or my wife has just been diagnosed with Alzheimer's or dementia, and nursing home care will be coming very soon. Some of the most important planning we do involves planning for these spousal circumstances. Planning when you're doing work to save the estate for kids really is just about the money. When you're doing planning that helps a well spouse preserve their quality of life, it's really much more gratifying and much more important in many ways, as your work will impact her or him for the rest of their lives. Most middle-class families have income in the range of $1,200 to $1,800 per month at the death of the first spouse, and for that reason, this planning will impact the quality of that surviving spouse's life for the balance of their life. The rules in this area tend to be very complex, in part because you have both the federal law and the state law impacting the Medicaid program. It's a joint federal-state program, and for that reason, you must not only know the federal law, you must know the state law. So prior to advising clients in this area, you need to become very familiar with your state code. The federal statute, as cited in the outline, is not that long, but it's something that bears study. There are no regulations at the federal level. The Centers for Medicare and Medicaid Services have not done regulations for this statute, which was passed in 1988. States vary considerably in this area. Some states offer very generous protections for a community spouse. Illinois, New York, California, Massachusetts all offer very, very generous protections both on the income side and the asset side. States like New Jersey, Ohio, and many southern states offer the most minimal protections as provided by the federal statute. Again, you must become very familiar with what protections your state offers. Further, in some states, the exempt assets varies considerably. In some states, IRAs, 401ks, 403bs are not countable assets. Likewise, in some states, income-producing assets, farms, family businesses are not considered countable assets. In other states, they are. In Ohio, for example, a family farm is a countable asset. An IRA is a countable asset. So therefore, you must, again, know the particular rules as it relates to countable assets in your state. The Medicare Catastrophic Coverage Act is really the basic code sections we need to deal with, and again, are cited in my materials. There are two sides to MECA, the Medicare Catastrophic Coverage Act, passed in 1988. The first side is the income test. The second side is the asset test. On the income side, the federal law provides that there's a minimum monthly needs allowance, otherwise known as the MIMNA. The MIMNA provides a base level of income that a community spouse can count on. Dealing with the 2011 numbers, and they change annually, the minimum monthly needs allowance is $1,838 per month. The maximum MIMNA is $2,739 per month. Some states, again primarily those states that I mentioned earlier, New York, California, Massachusetts, Illinois, and a few other states, offer a higher MIMNA than poor southern states or states like Ohio and New Jersey. It's important to know what your state does. In those states that offer an elevated level of protection, most people are going to fall within those categories. So for example, if a husband is going into a nursing home and he has $1,500 of Social Security, well, the wife has $1,000 a month of Social Security, what happens? Well, in those scenarios, in the more generous states, the husband will get to keep all of the income, or the wife will get to keep all of the income, with the exception of $40. That $40 is reserved for the husband for purposes of maintaining his, what they would call his needs allowance for purposes, personal needs allowance for purposes of shampoo, those sorts of things. The wife would get to keep the balance of the income, which in that case would be roughly $2,460 per month. In your less generous states, what happens? Well, in the less generous states, what would occur is she would get to keep $1,838 per month. His $40 personal needs allowance would be set aside, and the nursing home would get $622 per month. So as you can see, it's a very significant difference between one state and the other. What you're trying to do here in these circumstances is first explain the rules to this lady or this gentleman that are in front of you, whose spouse is going into a nursing home, and secondly, start planning for those circumstances. The income side is important in that, again, in the factual scenario given, husband has $1,500 a month in Social Security, wife has $1,000 a month of Social Security. Well, you may be able to obtain Medicaid benefits for the husband relatively soon. At his passing, his wife will have $1,500 a month of Social Security to live on, and that in most circumstances is not adequate. There can be an adjustment to the minimum monthly needs allowance. That adjustment deals primarily with the circumstances where the income is too low. So, for example, in a state that has a maximum MIMNA, the $2,739 per month, if they only have, between the two of them, $2,000 a month of income, you may be able to get an adjustment if necessary. And there's two types of adjustment. The first is on the income side. If, for example, the MIMNA in a minimum state is $1,838 per month and they have income of $2,000 per month, if she has rent, again, if the well spouse, community spouse has rent or utilities or taxes or other significant expenses that are above the ordinary, you may be able to get the MIMNA elevated from $1,838 to a higher figure. For example, if they have a mortgage payment per month of $1,200 per month, even in the minimal states, that MIMNA number of $1,838 is going to be raised to probably about $2,300 per month. And again, that will have a significant impact upon the monthly payment that goes to the nursing home. It may be reduced to zero. In your maximum states, it may not make much difference. As you can see from these brief examples, it's fairly complex and very nuanced, but you need to understand your local rules, your state rules, before advising clients. On the asset side, the asset minimum and maximum also, again, vary from state to state. On the asset side, the minimum community spouse resource allowance for 2011 is $21,912. The maximum is $109,560. And again, this varies from state to state. Again, your California, New York, Illinois, Massachusetts are usually going to be closer to that $109,000 figure, while Ohio, New Jersey, Oklahoma, and many poor southern states tend to be at the minimum, $21,912. And that adjusts annually. So in a circumstance where if the family has in the neighborhood of $30,000 in these states that are minimalist states, that $30,000 is going to be divided where the well spouse will get to keep $21,912, and the institutionalized spouse will have to spend about $8,100 for care. At that point, he or she would then be eligible for Medicaid. In your maximum states, that family that has $30,000 is likely eligible the day he goes into the nursing home. If they have $70,000, the way the test works, again, they take all the countable assets, they divide them in half. So if you have $70,000 of assets, that well spouse gets to keep $35,000, and the institutionalized spouse must spend $35,000. Again, in your states that are more generous, they may get to keep the whole $70,000. If they have $300,000, whether they're in a maximum type CSRA state or whether they're in a minimalist state, the result will be the same. The well spouse will get to keep $109,560, and the institutionalized spouse will have to spend the balance. Again, the basic planning that you look at must start with these basic rules. Again, in your more generous states, where IRAs may not be counted, where income-producing property may not be counted, and where the community spouse resource allowance is the maximum number, the planning is much easier in that most people already qualify. In most of your states that are minimalist states, you're going to have more planning is going to be required because, again, they're going to count the IRA, they may count the farmland or the income-producing property, and you have a minimum community spouse resource allowance as opposed to a maximum. Again, this planning is all based upon the Medicare Catastrophic Coverage Act of 1988. What you want to look at next is what sort of planning do you do? And that's also going to be affected by the Deficit Reduction Act. Although it's the Deficit Reduction Act of 2005, it actually became effective February 8th of 2006. In those circumstances where the community spouse resource allowance is not sufficient based upon some of the income rules, the Deficit Reduction Act limits the revisions of the community spouse resource allowance, and we'll get into that later. The Deficit Reduction Act also set forth new terms and restrictions for annuities and promissory notes. In some states, prior to the Deficit Reduction Act, many estate planners and elder law attorneys utilized annuities and promissory notes to shield assets, sometimes for the community spouse, sometimes for their children. That was severely limited by the Deficit Reduction Act, and you'll need to make sure that you review those rules very carefully, not only at the federal level, but also at your state level. There's probably 5 or 6 basic versions of the Deficit Reduction Act in the various states. Some have taken very different approaches than others. What do you do when the client comes in after you've done your study, after you've figured out what the rules are in your state? Well, one of the first things you do is generally you would come up with a series of options that a client would have, and some of these are very simple. Some are much more difficult. One of the first things we would often do is suggest that community spouse eliminate debt. The Medicaid code does not provide any benefit for maintaining most debt. The mortgage is the exception. So if a wife comes in, her husband's going into nursing home, and they have $15,000 in credit card debt, you can pay off that $15,000. It's not an improper transfer. You've helped her financial position because she doesn't have those minimum credit card balances to pay. You've helped her long term in that she now has a true economic picture as far as her wealth, and clearly the credit card interest rates will not continue to harm her financially. So one of the first things you would look at is paying off credit cards. The second item you would look at is usually paying off a car or other motor vehicle. And again, motor vehicle is exempt. One motor vehicle is exempt. A second motor vehicle, if it is handicap oriented, is also exempt. But the debt on those cars does not provide you any benefit. So in most circumstances, if they have $10,000 or $15,000 owed on a motor vehicle, after you pay off the credit card debt, you can also pay off that debt on the motor vehicle. You can also prepay taxes, whether it be income taxes or whether it be property taxes. Typically, particularly if the family's gone through a liquidation process to pay for care, there may be some capital gains taxes owing. Make it an estimated payment to the IRS or your state taxing authority is appropriate. And again, those debts that may be out there are not taken into consideration by the Medicaid program. Paying off the mortgage is a whole different subject. In some states, where the community spouse resource allowance and the minimum monthly needs allowance are at minimum levels, that mortgage may be helpful to you. So for example, if you're in a minimum monthly needs allowance state, which is $1,838 per month, and the wife still has a mortgage against the house and it runs $1,200 per month, if you leave that mortgage in place, her minimum monthly needs allowance may be raised from $1,838 to approximately $2,300 per month. So leaving that mortgage in place may be helpful. You could still pay it down somewhat, but you would not refinance it. Again, these are some of the nuances that you get into in this planning. Clearly, if she's well over the minimum community spouse resource allowance, paying down the mortgage can have immediate benefits. It can result in immediate Medicaid eligibility. If, for example, they have $100,000 in assets, you're in a minimal estate, and out of that $100,000 of countable assets, you pay $80,000 down on the mortgage, the husband may be eligible for Medicaid the next month. These are not improper transfers. These are appropriate payment of debts. In some circumstances, it's best to pay these debts after they go into the nursing home. Oftentimes when we get these cases, they're crisis-type cases, and paying down the debt after placement sometimes is beneficial. Again, it depends very much on your circumstances. If by chance, again, this is your second option by way of planning, if by chance the income of the community spouse and the institutionalized spouse together is less than the MIMNA, the minimum monthly needs allowance, you may be in a position to ask that the community spouse resource allowance be revised. This is one crossover section in the federal statute that protects those with very low income. And we still see some circumstances where perhaps the wife has $500 a month of Social Security and the husband has $800 a month of Social Security. In those circumstances, a community spouse resource allowance revision would be appropriate, particularly in those states with a minimum community spouse resource allowance as well. If they're permitted to keep, let's say, $30,000, they have a $60,000 total countable assets, and their total income is $1,300, you may well be able to keep the entire $60,000 and have the husband eligible for Medicaid immediately. This may not sound like a significant sum, but for that elderly couple, allowing her to keep, assuming she's the community spouse, allowing her to keep $60,000 instead of $30,000 is a significant benefit to her. In order to do so in most states, after you do the Medicaid application, and you must do the Medicaid application before they've spent down, you do the Medicaid application, typically you would have to request a fair hearing and ask that the agency adjust the community spouse resource allowance in that circumstance from $30,000 to $60,000. It is not an easy process, and most states have made it more difficult. Some states have actually allowed a guardianship proceeding or a probate proceeding to do that. That is the exception to the rule. Again, you'll need to become very comfortable with the procedures in your state for purposes of doing a community spouse resource allowance adjustment. In those circumstances where the income of the community spouse and the community spouse and the institutionalized spouse are at or above the minimum monthly needs allowance, it is unlikely that you will get an adjustment. The case of Bloomer versus Wisconsin is a U.S. Supreme Court case that you must read in order to get a good feel for this area of law. In that circumstance, the state of Wisconsin attempted to restrict community spouse resource allowance revisions. The courts in Wisconsin stood with ruled for the applicants and against the state, and eventually the state appealed that case to the U.S. Supreme Court, and the U.S. Supreme Court decided 6-3 that the states were permitted to restrict these revisions based upon the income of both the institutionalized spouse and the community spouse. In the past, we were able to obtain adjustments where the community spouse's income was very low, and particularly in those circumstances where the income would stay very low. That again has been restricted in part with the Bloomer case, and also in part because of the Deficit Reduction Act of 2005. In some circumstances, it's appropriate just to spend down. Again, in those circumstances where they've done all the appropriate planning, they've done the prepaid burial, they've paid off the house, they've paid off the car, they've paid off the credit cards, and they still need to spend some funds prior to him being eligible for Medicaid, you simply write the check to the nursing home, you write the check to the pharmacy until you get down to that magic level. Typically, in most circumstances, once we've determined what that amount would be, we would have the community spouse set that amount aside in a separate account, and when the expenditures have brought her down to that amount, then we would apply for Medicaid. So for example, if they start out with $60,000 and we determine that after all the expenditures there's $50,000 left that needs to be divided, we would set aside $25,000 for each, and when the total assets were down to $25,000, we would then apply for Medicaid. Again, there's nothing wrong with doing a spend down if it's required. One of the more difficult subjects we're running into is when do you annuitize? This is a fairly hot subject around the country. It is being litigated in multiple states. The Deficit Reduction Act provided some guidance and some restrictions as to the use of immediate annuities. And for purposes of explanation, an immediate annuity, for a layperson, it's really fairly simple to explain. You send the insurance company a sum of money, and they agree to send you a certain amount of money back every month. You cannot liquidate that annuity. You cannot cash it in. It is now an immediate annuity, also known as a SPIA. That annuity is an insurance product, and essentially it converts assets into income. The federal statute, the Deficit Reduction Act, specifically made reference to tax-deferred funds such as IRAs, 401ks, and 403bs. If you're annuitizing those funds, typically what you're doing is you're turning a pension-like asset back into a pension. And the monthly income can come out of that. It must not be, it must be based upon the age of the owner. It can be payable to the owner or their spouse. There cannot be a balloon payment at the end. The payments must be roughly equal, and they must be consistent with the Social Security Act as far as the length. Must be based upon the age of the owner or the owner's spouse. These SPIAs are an appropriate tool. What happens, however, if you decide to become very aggressive and decide to use one of these tools for non-IRA funds. That's when things get a little bit more dicey. Again, the litigation in New Jersey, Pennsylvania, Ohio, and I believe there's several other states, is ongoing at this time, and it's not an area where we have great comfort. There are two ways that you do this planning. First, if the nursing home placement has not yet occurred, these tend to be a lot safer, again, because you have not done what they call snapshot for purposes of determining the countable assets. So if you've annuitized the IRAs and 6 weeks later the husband goes into the nursing home, you have a stream of income which you must report, but the underlying asset was converted back into an annuity product prior to date of placement. If you do it after date of placement, the caseworker is going to go back and say, well, here were your assets on the date of placement. And then they divide those into and say, well, you should have spent that other amount down. You should not have purchased an annuity with it. So you may well be in a situation in your state where litigation could occur. If it's already occurred, the placement's already occurred, you need to advise the client of the possibility of litigation. You need to advise them as to position your state is taking as it relates to the purchase of this insurance product. It is a good planning tool. Be very clear about that. In those circumstances, again, where client has $50,000 to $150,000, and the wife has $1,000 of Social Security per month, and the husband has $1,500 of Social Security per month, when he passes away, she's going to have a hard time living on $1,500 a month. This annuity will provide her an additional income, perhaps for the rest of her life. So it's a viable tool. It's an appropriate tool to get her income up to a level where she can live independently and with some comfort. Again, the goal here is to preserve a stream of income. It should be noted that one of the beneficiaries in these annuities, after you get beyond the applicant and the spouse or a disabled child, must be the state. So there's really not generally a benefit in these type of annuity plans for most heirs. And again, that's one of the restrictions brought in by the Deficit Reduction Act. You must name the state as a beneficiary. What I've tried to do is kind of create a little bit of a table here so that you can see the risk levels. And again, the table starts with the top. The highest risk is a SPIA purchase with non-qualified funds, and I would include IRAs in that category as being a qualified fund after date of placement. So if the family has no IRAs, no 401ks, but they do have $200,000 set aside in various savings accounts, stocks, bonds, and you annuitize $100,000 of that after date of placement, that may cause a difficulty, particularly if you try to apply for Medicaid fairly soon after that annuity is purchased. So if you've attempted to do that, the caseworker may indicate that that $100,000 will be treated as an improper transfer. You're then in litigation. Caseworker may determine that fine, we'll let you do that, but of the $100,000 that remains, there's a $50,000 spend down. So they would reduce the CSRA down from 100, perhaps down to 50. Again, but you have some risk there. The second highest risk are those used with IRA or other qualified funds after date of placement. I think the risk is lower there, although in some states they are still challenging those. Again, the code specifically refers to retirement plans. The federal code refers to specific retirement plans, but the states are not necessarily adhering to that. The third level, again, this gets a little safer, is if prior to nursing home placement, you purchase the SPIA. If you purchase the SPIA prior to placement, you're going to be in a position where when you apply for Medicaid, they're going to ask for the assets as of date of placement. You will show them the assets as of date of placement, which will not include the funds that were annuitized. I think as a matter of ethics and a matter of state law, you likely have to notify the agency that you did the SPIA. Usually we give them the contract. We relate to them the amount that will be received each month. And keep in mind, in many of these circumstances, that SPIA also impacts the amount of income allocated to the community spouse. For example, if they had $200,000 of assets, you purchase the SPIA prior to date of placement, and it produces an extra $500 a month of income. If the wife has $1,000 a month of Social Security and the husband has $1,500, most of that $500 is actually going to probably go towards the nursing home while he's alive. But at his death, if done correctly, she continues to receive that income. Finally, a SPIA done prior to placement with retirement monies, again, 401k monies, 403b monies, or IRA monies, has likely the lowest level of risk, and it's something that should be heavily considered in almost every one of these cases. Again, the SPIA can be an IRA SPIA, so it does not necessarily generate any income tax over and above the ordinary that would be taxed by way of the withdrawals. So again, the SPIA payments out of that IRA annuity will be taxable, but they'll be taxable as received. If done incorrectly, if you move the IRA monies into a non-IRA SPIA, you've probably suffered quite an income tax burden by doing so. Next planning option you can look at is a gifting plan. The look-back period is now 60 months, starting February 8th of 2006 in most states. The period of time runs from the month after the gift. And this is a fairly straightforward type planning if you have enough funds and if you have enough time. So if there's been a diagnosis of Alzheimer's, but placement may not occur for several more years, this is a viable planning option. But again, be aware that the 60 months is a pretty hard, fast rule. Anything within the 60 months by way of gifts will be considered and will be considered as part of a penalty period for purposes of Medicaid, which we will not get into as part of this lecture. If you're going to enter into this area, you first must review the federal statutory law as it relates to spousal impoverishment. And you'll find most of that, again, I've identified the code section in my outline. It is not a difficult read, but it's one that you need to go through, and you probably need to outline each section. You probably need to review some of the materials in some of the NAILA, from some of the NAILA programs as to spousal impoverishment and planning. You also must review your state regulations and your state statutes. Again, if there's a NAILA chapter, you may want to attend some of their CLE presentations. If not, your State Bar Association may offer some of those. You must become very familiar with your state rules. Your state rules are generally going to govern what planning you can get into. Finally, try to plan cautiously. Most of these folks in these circumstances are really in a bit of a crisis. They've just received very bad news, or they've just placed a spouse in a nursing home. They're emotionally vulnerable, and you can do a great deal of service to them and help them not only make it through the application process, but also be in a position where they can survive with a little bit more income, a little bit more assets as they age. In most of these circumstances, the community spouse will outlive the institutionalized spouse for a number of years. And what we're doing is we're really trying to fulfill the intent of Congress in 1988, and that is to avoid spousal impoverishment as our clients age. I think you'll find this area very rewarding, and to that end, again, give great care to the client. Do not underestimate their needs. Do not attempt to make this sound simple and easy. It's not. They need to understand the complexity, and if you do so, I think you'll find this area will provide you a great deal of satisfaction helping people. Thank you.